I ask you
the court can decide those.
Can I ask you the same question, or maybe just a very similar question in a different way? You've been asked about a number of different agencies. A few of them are likely to come before us in the near future because of actions that the president has taken. Others, as you point out, have not been featured in litigation of which I'm aware up to this point. So suppose we were to decide this case in your favor without reaching some of the agencies that have been mentioned, like the tax court and the claims court and the Court of Appeals for the Armed Forces, to name three. Suppose we were to decide the case in your favor, but we did not want to address those other agencies. On what ground, one way or the other, to express a view that would affect those agencies, either, as I said, one way or the other? On what would you propose that we say, so as to reserve decision on those agencies that may not come before us in the near future, or perhaps at any time in the future?
I would, I think, use the language that the court used in Free Enterprise Fund when it said we do not decide the status of lesser functionaries. It pointed out that the dissent in that case and itself pointed out that the federal bureaucracy is vast, and it said we don't want to decide, given the size and variety of the federal government, that discourages general pronouncements on matters that are not briefed and argued. Now, as to, for example, non-Article III courts, I'm not even aware of litigation about those removal restrictions for any of those.
But you're not